Good afternoon, everyone, and welcome to our latest commercial property update webinar. Really pleased to see so many people signed up and so many people in attendance today. As usual, we're going to look to cover three different topics over the next hour, and we're going to look to make sure that we're done by 1:30. First up, Vicky, a partner in our information law team, is going to look at GDPR. It's 5 years now since that came in, with a particular reference to those with an interest in property. Next up, we'll have Amory, who's a senior associate in our property litigation team and is going to look at the often thorny issue of break options and break notices in particular, looking at that from both a landlord's and a tenant's point of view. And then finally, Mark, a solicitor in our commercial property team, is going to look at a couple of recent cases that have been of note, in particular around service charges and renewal under the Landlord and Tenant Act 1954. As Romney said, if you've got any questions, do pop them in the Q&A box and we'll endeavour to deal with those at the end. And if not, we can certainly look to follow up afterwards. But without further ado, I'd like to now hand over to my colleague Vicky Bowles, who will do the first session.
Thanks very much, John. If I can have my first slide, please, that'd be great. So I'm going to talk to you very briefly about GDPR. It'll be 5 years at the end of this month since the GDPR came in, and you won't be surprised to know that I can talk for hours about all of the exciting things that have happened over the last 5 years, but luckily for you, I've been limited to 15 minutes today. So I'm going to focus on three areas: marketing, cybersecurity, and new technology. And the reason I'm focusing on those areas is because the first two are the most high risk areas in terms of data protection. And the last one is a new one and it's interesting. So I thought I'd finish with something a little bit more exciting. Most organisations, and certainly all of the organisations that I deal with across the board, so I work with commercial clients, education clients, charity clients, property clients, everyone, generally speaking, takes a risk-based approach to compliance with data protection law. And the reason for that is there are a lot of areas in data protection law where the burden of complying just simply massively outweighs the actual risk of not complying. So most organisations take a risk-based approach. If I was to highlight the first, what we've learned from the last 5 years, really, is that the ICO is most interested in breaches of marketing rules and in breaches of the rules around security. And those are the two areas where we consistently see fines being levied. So those are the two areas I'm focusing on because those are the highest risk areas. Have the next slide, please. So in terms of marketing, as I said, it's one of the two main reasons why the ICO issues fines to organisations. And it's not just the risk of having a fine from the ICO, there's also reputational issues for organisations that are seen to be in breach, and also individual claim issues. And I think the issue with marketing in particular is that we all know from our personal lives that you get inundated with emails promoting this, that and the other. I know I get hundreds in my my own inbox, and I'm pretty good at not giving consent and opting out and all of those things, because it's a really easy and cost-effective way to market a business. And there's nothing wrong with sending marketing emails to individuals. It's absolutely an effective way to market your business, but it does annoy people, and because it annoys people, if they think you've breached the law, they're more likely to complain. So this is why it's really important to try and get that right. So things to check. If you are relying on consent to market to people, you don't always have to, unless you're sending unsolicited emails to individual people and not companies. And I'll talk about the soft opt-in in a second, but as a general rule, if you're sending emails to people that they haven't asked for, and you don't have a existing relationship with them, you need prior consent to send the emails. So if you are relying on that and using consent, make sure that you do have consent before you send the email. Check how you refresh those consents as well. In Ireland, there's a rule that consents have to be checked every sort of 12 months. We don't have a similar rule in the UK, but 12 months is a fairly reasonable period. 2 years might be a reasonable period actually in some cases, as long as you can justify it. But so check you have consents, check they're up to date and how you update those, and make sure that you're checking your do not contact list, because that's one of the certainly some of the breaches that I see in relation to marketing are just because the individual who's sending the email didn't think to check or didn't know that there was a do not contact list. So making sure that everybody involved knows that there's this list to check against. So I mentioned that if you're sending emails to people who haven't requested them from you, that you need prior consent if you're sending them marketing. There is what's called a soft opt-in. So that applies if you've got an existing relationship with a customer, with a tenant or whoever it might be. You've got an existing relationship with them and you are promoting something similar to the original product or service that they bought from you. If you are doing that, you don't need consent, but you do need to have told the individual at the time you took their contact details. So let's say you are an organisation that leases residential property to individuals. So when you get tenants on your books, you say to them, and we might promote similar services that we have to you in the future. If you don't want to receive these emails, let us know. Either tick a box if it's an electronic form or send an email to the right person. And then every time you contact them after that, you need to give them the ability to opt out. And you might want to do that because you might have tenants who you know are going to buy a property later on, and they might want to lease that property and they might want to use your property management services. So you would then be able to promote those property management services to those individuals if that was something you want to do, provided you've done all these things leading up to it. So just making sure that you understand the rules and that they're being applied, and everybody who's working in that area understands what they're doing. And then finally, checking on your cookies, because cookies, I don't really understand actually technically what they are, but they are tools that you can use on your website to collect information, and you can use that for marketing purposes. But there are different rules again that apply to the collection of cookies. You'll all know when you click onto websites, you have to actively consent to certain cookies being placed. So if you are using these cookies, and quite a lot of clients that I deal with who have websites, their website developer sets them, they don't even understand what they're actually collecting and using. Make sure if you are using cookies, someone in your organization needs to understand what you're collecting and how you're using those. Next slide, please. Cybersecurity is the other reason that organisations get fined. And if you only take one message away from my part of the talk, I'd like it to be this: cybersecurity is not just an IT issue. It's not something that you can just download some software to fix and it's done and you don't have to think about it. Security and cybersecurity as well are issues that are across the organisation, and everybody's responsible. In the GDPR, there is a legal requirement for you to take appropriate technical and organisational measures to protect personal data. So it's a legal requirement to put in place measures to protect the information that you're holding. And that doesn't just mean firewalls and encryption and geolocation, and I can keep listing terms that I don't understand, IT terms. It doesn't just mean that IT thing. It also means doing basic things like looking at your password strength, making sure that you've got access controls, so that if you've got different people in an organization working on different things, the classic is HR and finance. Do the HR people need to see the finance information? Probably not. The reverse is true. The finance people don't need access to the HR information. So making sure that that's all partitioned. Locking your screen when you walk away from your computer. I do that. I'm at home alone at the moment. When I get up in a minute to have some lunch, I will lock my screen because it's so ingrained in me to just lock it whenever I stand up, even if I'm only going for 2 minutes. Remember that individuals are usually your weakest link, and a lot of the fines that have been issued actually are where organisations have, it's usually been a perfect storm of issues that have combined into one big breach. But they're usually caused, or the root is an individual who unsuspectingly downloads some malware or falls victim of a phishing scam and puts their password into the wrong website. And these are things that, although you can't prevent, in the sense that we're all human and we all make mistakes, if you don't give training to your staff and people who you're working with to teach them how to spot these scams and avoid them, then it's more likely to happen. So staff training is really important, and that is an operational measure that the ICO does say in most cases is required as a sort of bare minimum. So staff training and policies and procedures, don't forget those. If you have time, there's a really helpful enforcement notice that the ICO gave to Interserve, a company that, as I said, had one of these perfect storm situations, and one of the and there's a whole list of reasons why they were fined, and they were given quite a significant fine. But one of those reasons is because they had an incident, and had they followed their incident policy or procedure, whatever it was that they had, they would have noticed that the threat actor, so the person who'd got into their system, was still there, and they potentially could have limited the access and then mitigated a huge amount of the eventual problems that they had, because this individual was still in their system and just sat back quietly and waited months before they then did whatever it was they wanted to do. So had they had the policy, they just didn't follow it. So if you don't have policies and procedures, put them in place. And if you do have them, make sure you follow them, and make sure as well that when you do follow them, if they don't work, you change them and adapt them and make sure they work for you in the future. Next slide, please. Sorry, this is a bit of a whistle-stop tour. I do a whole day's training course on cybersecurity, so I've just tried to smash that into sort of 5 minutes, but hopefully you get a flavour. Finally, new technology. We're all using newer technology, and particularly, you know, with AI and everything coming in, and we're all sort of scared of that, trying it, seeing how it works. But there's also an increase in using things like biometrics for access to properties, facial recognition, smartphones, etc. And if you're installing those in your properties, then you will be collecting personal data. Now, you may be collecting it as the data controller. It may actually be physically being collected by a third party on your behalf, but you need to make sure that you understand your legal position, and then you understand the agreements you have in place with that third party. Because if you are the data controller and you employ a processor, legally you are still liable for that data, even if the processor does something wrong. So if you've got a company that's installed facial recognition for access to a building, they're collecting personal data, they have a data breach. Legally speaking, you are then responsible for that and responsible for all the costs. If you don't have the right type of agreement in place and you don't pass those costs on, you're potentially then stuck with the financial liability. So the new technology and everything is great, and there is an increase in people sort of asking for this and expecting a certain level of tech in new homes and in offices and in properties. So if you're starting to embrace that and use that, do make sure that you understand what the position is around the personal data, you understand who's collecting it, where it's going, and that you've got the right agreement in place. That's my whistle-stop tour of GDPR, and I'm now going to hand over to Amari, who's going to talk to you about break clauses.
Thanks, Vicky. Hi, everyone. I'm Amory. I'm in the property litigation team, and I'm just going to be running you through some considerations when serving a break notice or looking at break clauses in commercial leases. So firstly, what is a break clause? A break clause is an option in a lease enabling a landlord or tenant, or possibly both parties, to terminate the lease early, i.e. ahead of the contractual fixed term of the lease. Some general points about break clauses and leases. They provide flexibility. A party may have negotiated a break clause into a lease for various reasons. The market conditions, not wanting to commit to a location long term, the economic climate, not there are it's more common for leases to have breaks these days, or possibly shorter terms, because people are looking for flexibility. If you're, say, a startup, you might want to factor in some risk and want to have a break in your lease. They are strictly interpreted, so they are break options tend to be fairly prescriptive. They might require a notice to be served and then have certain conditions attached to them. It's seen as a right, it's a luxury as such, so they generally are exercisable within certain parameters, so there are things to look out for, and the consequences of not serving a break correctly or not complying with the conditions are that the break notice will not end the lease, and then the lease will continue until the end of the term or the next break date if there is one. So obviously that can be quite a serious consequence for someone who or a business who is trying to get out of the lease. And they can be quite contentious from both sides. So a landlord in particular at the moment may struggle to relet, so they might be scrutinising a break notice to make sure it's been served correctly, in case there was an opportunity to lock the tenant in for the rest of the term. And finally, a break notice is irrevocable once served, so you need to be sure you are wanting to end the lease before you serve notice. Next slide, please. This is an overview of what I'll run through today. So there are the initial considerations, and then going through to serving the break notice, and then the conditions that might be attached. And I'll go through those in further detail. Next slide, please. Firstly, initial consideration. So this is the first stage of the process, and there can be different types of break clauses. You can have a tenant-only break, a landlord-only break, or a mutual break. There are one-off breaks or rolling breaks. A one-off break means that there is only one date in the lease where the lease can be terminated, or there might be one or two or three depending on what was agreed. And a rolling break is a more flexible type of break where, say, a break notice can be served after a particular date, and it may say something along the lines of the tenant must give X number of months notice to terminate the lease at any time after a particular date. So that's particularly flexible. And then sometimes there may be a trigger event. So for example, if a landlord has a break option within a lease, say because they intend to redevelop the property, the trigger event might be, say, when they get planning for that redevelopment. So that then when that happens, that allows them to serve the break notice. Another thing to look at is, can the break be exercised by the person who wants to do so? Is it a personal right? So sometimes in leases, that right might be personal, say, to the original tenant, or it may say the tenant can serve the lease. So you would need to check the definition of tenant. Does that include successors in title? So if the lease has been assigned, does that new tenant have the right to serve a break as well? And then, do you have sufficient time to serve the break? Fairly common is a 6-month notice period. It can be more, can be less. So when you are looking ahead to whether you want to exercise a break on a certain date, if it is 6 months notice, say, you probably want to be looking at it a year, 9 months, 8 months before, so that you've got a couple of months to get everything in order and serve. And then the timing and planning ahead. For a business, there will be a decision-making process for whether you want to serve, and it depends on the circumstances of the business at the time. So know who needs to sign off the decision, start talking about it early, and take advice early. There's quite a lot to think about sometimes, depending on the nature of the lease. So there's no harm in getting your advice early and perhaps sharing it internally, and then knowing when you need to make a decision. And it's best not to be making decisions under pressure. Next slide, please. Next stage is actually serving the break notice. You might be doing it yourself if you deal with these kind of things in-house, or you might be instructing solicitors. If you are instructing solicitors, you will need to get the advice on the conditions ahead of serving. You need to know when the conditions need to be complied with, and plan ahead to make sure that they can be complied with. Sometimes conditions need to be complied with as at the date of serving the notice, or they might be as at the date of termination of the lease, or it could be both. So that's why you need to know ahead and obviously get everything in order before serving. And planning to ensure conditions can be met. As an example of a condition, you might need to pay a premium. So if that's the case, are the funds available? Who in finance needs to sign that off? And can you make sure that that's in order and that the money will be available when it needs to be paid? And then looking at drafting and method of service, this all comes down to looking at the lease, what it says in the lease, and everything must be followed exactly. As I mentioned, the break notices and break clauses are very strictly interpreted, so the lease needs to be scrutinised, and then there are lots of those bullet points kind of cover off things, the type of things we'd be looking at. But the form of notice, not often, but sometimes there might be a prescribed form to use. Otherwise, does it indicate that specific wording needs to be used? Do you need to refer to a particular clause? The notice period I mentioned, make sure you are giving sufficient notice to work that out. And I've said to check the dates. Sometimes the break date might be a specified date, or it might be, say, the anniversary of the term, or it might be the day before the anniversary of the term. So all these little nuances and things to check if it's not an express date. And looking at the addressee, which is normally your direct landlord, but there might be two landlords. Do you need to serve on both? Are you sure of who your landlord is? If it's a big fund, you might not have direct access with them and always dealing with agents. So there are certain investigations we would do to work out who the direct landlord is, including looking at the title. And method of serving. How are you serving and where are you serving? So there could be multiple methods and addressees. It's not just looking at the break clause in the lease, or the lease needs to be looked at as a whole, and you'd also be looking at the service provisions. So there could be prescribed methods of service, quite common, as say by registered post or first class post. And you may also consider serving by hand. And if the landlord, for example, is based overseas, that's something else to consider, how what postal method you can use. Might you need to use a process server in a different country? So lots of things to think about there. And I've mentioned deemed service. So sometimes a lease might tell you when a notice will be deemed served. So for example, if you send something by special delivery today, the lease might say it's deemed served in 2 days' time or in the ordinary course of service. So that's just something, in addition to your notice period, you need to allow a couple of days for allowing something to be served. So you need a bit of a cushion there. And often we find you tend to cover all bases. So if you have multiple addresses for the landlord, looking at Companies House, looking at their title, you may want to serve at multiple addresses to cover all bases. Next slide, please. And then the final stage, which kind of runs throughout the process, is looking at the conditions. So understanding the conditions ahead of service, be clear on what you need to do, and always refer back to any advice that you obtained ahead of serving the break notice, because it's the requirements are sort of ongoing until you actually exit the lease. And I've detailed 3 common conditions that you might see attached to serving a break notice. One of them is payments being up to date. So you need to check what you need to have paid and by when. So do payments need to be up to date at the date of service and or at the date of exit as well. So practical points there are checking historic payments, and you may not have been, say, working at your current business when the lease started, so that might be speaking to finance to check and scrutinise historic payments to see that everything is up to date. And the definitions are important on this, because what does the actual condition say? Does it say you need to have paid the principal rent up to date, or all rent? So does that include service charge and insurance rent as well? So knowing exactly the sums that need to be paid. Not so often anymore, but there are some older leases have very onerous payment conditions. So for example, all sums need to have been paid up to date, which includes anything and everything due under a lease, say utilities, interest, etc. And there is case law on a unfortunate for the tenant in this case, where a very small sum of interest accrued on late payment, £100 or so, and the landlord scrutinised their payment ledgers and found this was due, and managed to frustrate the break. So lots to think about there. And the second point is, normally you need to give up possession when at the break date, which makes sense because you're leaving the property. A vacant possession is an onerous type of giving up possession, which we don't see as frequently, but it's sometimes in older leases or some leases now, and that means clearing the property completely, and there's a very high threshold for that. And there have been cases where the tenants left a couple of items at the property, so bags of rubbish or furniture, say, and there's been an argument as to whether vacant possession has been given. More often now you see the phrase giving up possession or free from occupation, which sort of means the same thing, but if you left the odd thing at the property, that wouldn't necessarily frustrate that condition. And finally, a premium. Sometimes you see a premium payable as a condition. Things to think about there are, when does it need to be paid? Is it when you serve the notice? Is it on the break date? Is it expressed as a figure? So is it clear what you need to pay, or does it say, for example, 6 months, the equivalent of 6 months rent? And if so, the rent may have been reviewed over the term, so you need to know, was it the rent at the start of the lease, or any reviewed rent, or the current rent? Is VAT payable on that figure? Does it give you a method of payment? Do you know the landlord's account details? If any of that is not in the lease, which it might not be, you need to check with the landlord where it needs to be paid, or you might want to pay it to your rent payment account. But that's the kind of thing that you'll need to be discussing with your internal team and your advisors. And then next slide, please. A little bit more on conditions. So this is the stage where the steps, so you've served the break notice, and then this is ahead of the break date. So you need to diarise your break date. You need to monitor that date. Be aware of ongoing payments. I just mentioned a payment condition. As just an example, say if your break date is October, and before that and your rent payable quarterly, then the September quarter rent will fall due ahead of your break date. One pitfall is thinking, oh, I might apportion that September rent until October because we'll only be in occupation for another month or so, which is a big no-no. So if it says payments need to be made up to date, that means all payments are anything that's fallen due, i.e. the full quarter's rent in September. Some leases now will contain a provision which allows or obliges the landlord to repay any overpayment following the break date. So you will get that money back, but even if the apportionment clause is not in there, then you still need to pay the quarter in full. And so be in touch with your accounts team, make sure they know to pay invoices that come in, or know what needs to be paid. Who is responsible for overseeing? So it's divvying up responsibilities, really. If there's one person within the business, then they need to be coordinating with, say, accounts and other teams, so everyone knows what they're doing, and plan for the exit as well. So depending on how big the premises is, there's a lead up time to make sure you can move everyone out, get your contractors in. If you're looking at doing repairs or dilapidations, you might be instructing a surveyor. So have an action plan and timings for getting people on board. And then finally, I've mentioned in relation to conditions, communicating with the landlord. So in this process, the landlord doesn't necessarily need to be helpful, so they don't need to acknowledge the break or tell you you've complied with all the conditions, etc. So they may stay silent, and actually you don't need to do the tenant any favours. So if you stay quiet, that's just reserving your position. But one thing a tenant can do is to reach out to the landlord. So just try and start up a dialogue to smooth the way. So if you know the notice has been served, you can just ask them if they've received it. If you have a point of contact, ask them if who they should get in touch with in terms of exit arrangements, handing back keys, access passes, etc., to just try and smooth the way and gauge whether they are on board. And it's often useful to know if a landlord is ready to relet, then they'll work with you to make sure you're out on time. Next slide, please. These on this slide, I've just got some other considerations which kind of crop up day to day when looking at break options. The registration gap, which lots of property solicitors generally are dealing with at the moment, is essentially the land registry backlog in processing applications. So if you are tenant serving a break notice, you might be aware that your landlord sold its freehold interest last year, but they may not yet be registered as the owner with the land registry. So you've got this odd twilight type position where you know who your landlord is, but the legal owner is still your previous landlord. So that's something we advise on regularly, and often means that you might need to serve on two parties, which can be an added complication, and just explain to the recipients what you're doing. But that's something that is relatively new, in that sort of 10-15 years ago we didn't have these backlogs, so it's a new thing that's been considered. And the post, there have been strikes recently. Snow in the past has delayed post. There's lots of things that can happen. So when you are serving, it's just keeping an eye on what's going on and making sure you've got time to serve by post, and you might need to be considering service by hand or hand delivery or process server if needed. And dilapidations, if you are exiting a property, that's something you'll be looking at generally, your repair obligations, or if you're a landlord and you receive a break notice, you know your tenant's leaving, so you might want to look at getting a schedule of dilapidations put together. So that kind of notice period is the time to look at those things. If the tenant's doing work, they might want to get the surveyor on board, try and negotiate a settlement and to wrap everything up at the same time. And sometimes you get break conditions which relate to the repair standards of the property, so it sort of spills over into dilapidation. So that's something which you'd want to get your perhaps a surveyor to look at an early stage. And renegotiating terms and documenting them. One reason a tenant might serve a break notice is because they think actually this property's over rented, and they might want to serve a break notice looking to renegotiate new terms with the landlord, and the landlord may be amenable to this if they want to keep the tenant in occupation for whatever reason. So if that's the case, or perhaps the landlord reaches out after you serve the break and says, look, are you sure you don't want to stay? You might be able to negotiate new terms. And if that's the case, just make sure that happens fairly quickly. You don't want to be up against the clock with the break date approaching and be under time pressure. Or if you're not ready to leave yet, or you suddenly realise you need a couple of more months, then reach out to the landlord and see if a deal can be done. And finally, surrender. A surrender is a formal deed which terminates the lease. So that's something that could be attractive if, say, there are fairly onerous conditions, and that would give the tenant certainty. Or say if you've dealt with dilapidations at the same time, you might want to enter into or invite the landlord to enter into a deed of surrender, just wrapping everything up and in relation to that exit, which can be beneficial to both parties. Next slide. So just to finish up, these are some top tips for dealing with break notices. So do take advice early and have a roadmap. There's lots to think about. Time is a useful thing to have when you're making these decisions, and I mentioned things can crop up, so give yourself time. Instruct early, and which goes to the above point, and also a surveyor if needed, to get this kind of professional team together for your exit. Check historic and ongoing payments from the start of the lease, and speak to who you need to internally. Make sure someone's checked that, and you might want to check yourself and see the evidence of all the payments. That's the kind of thing that can crop up, or you think you've checked and then someone will say, oh, actually we've noticed this payment was late, and so there could be things to try and sort out along the way. Do not take risks. If in doubt, take the cautious action. The apportionment is one thing, because that seems entirely practical, as in you're leaving on a certain date, you only want to pay up to that date, but don't do anything like that, which seems practical and sensible, but it may have an impact on the break. Ask questions. If you've taken advice, reread the advice, pick up the phone, talk through, just don't leave any stone unturned as such. So just make sure you thoroughly understand what needs to be done before the break date. And finally, communicate internally and assign responsibility. So you might be instructing a solicitor, but you also want to speak to your, say, operations team who are dealing with the exit, and assign, and your accounts team who deal with payments. So everyone needs to know what they need to do. That's everything from me. I'm now going to pass you over to Mark with a commercial property case law update.
Thank you very much, Anne-Marie, and good afternoon, everyone. My name is Mark Edmonds, and I'm a commercial property solicitor in our London office. I'm going to be providing a case update on 2 cases today that I hope will be of interest, but are certainly relevant when it comes to commercial property. Next slide, please. So the first case being a Supreme Court decision in which the Supreme Court looked at whether the Court of Appeal erred in its construction of a provision in a commercial lease regarding service charges. And the second case being a High Court decision in which the court considered what the correct test should be applied to as to whether a landlord has established sufficient intention to redevelop. And this is in order to satisfy their ground of opposition to a renewal tenancy under section 31F of the Landlord and Tenant Act 1954. Next slide, please. So starting with our first case, Sarah and Hussein Asset Holdings Limited and Black's Outdoor Retail Limited. Just as a bit of background, Black's Outdoor Retail Limited, the tenant, rented commercial retail premises from Sarah and Hussein Asset Holdings Limited, the landlords, under 2 successive leases. And the relevant clauses that we'll be looking at stated that the landlord should provide a certificate as to the amount, the total cost for service charges and the sum payable by the tenant, and that this was to be conclusive in the absence of any manifest or mathematical error or fraud, which were the permitted defences. Now, an issue arose when the tenant actually refused to pay the service charges for the 2017-18 and 2018-19 years. And our service charges amounted to just over £400,000. And the tenant claimed that the service charge was excessive and included unnecessary items that actually were not properly due under the terms of the lease. So the landlord proceeded to issue proceedings and sought summary judgment for the outstanding service charge. And they argued that the certificate as to the sum that was due was conclusive, again subject only to the defences, i.e. manifest error, mathematical error or fraud. But the tenant argued that the true meaning of the provision in the lease was that the certificate was conclusive only as to the amount of costs incurred by the landlord, not as to the tenant's liability for service charge. Next slide, please. So the landlord's application for summary judgment was initially dismissed, and their first appeal was also dismissed. However, the Court of Appeal allowed their second appeal and actually entered summary judgment in favour of the landlords, going back to the High Court with the question of what, if any, counterclaims that the tenant could actually pursue. Now, when the Supreme Court looked at this, they dismissed the tenant's appeal against the summary judgment in favour of the landlords. And if we look and consider the Supreme Court's deliberations, we can see how they came to this conclusion. Next slide, please. So when looking at the landlord's arguments, the Supreme Court saw that there were several potentially arguable issues which could arise as to liability for service charges under the leases. Now, the permitted defences were quite narrow and didn't allow for an arguable error. So the Supreme Court felt that it would be surprising for the parties to agree that arguable issues, including liability, could be determined conclusively solely by the landlords without any opportunity for the tenant to challenge this. And the court found that it would effectively create a pay now and argue never regime. And instead, the court followed the established principle that interpreting a contract, there's the presumption that neither party intends to abandon any remedies which arise by operation of law. And when the Supreme Court considered the tenant's submissions that the certificate was conclusive only as to the landlord's costs and not the sum to be paid by them, the court again felt that this interpretation contradicted the meaning of the certification provision in the lease, and that the certificate was conclusive both as to the amount of the total cost of service charge and the sum payable by the tenants. And in addition, the court looked at the commercial reality in allowing the tenant to challenge payment of the service charge completely undermined the purpose of enabling the landlord to recover costs and expenses without substantial delay or indeed dispute. So the court followed that the tenant's argument created an argue now and pay later regime. So ultimately, the Supreme Court majority found that there was an alternative interpretation that avoided both these flawed views. The court considered that the landlord certificate was conclusive as to what was required to be paid by the tenants, and it was subject only to the permitted defences outlined in the lease. But the landlord, and this benefited obviously the landlord in that they could be assured of payment of the service charge without the any delays, and obviously assists in the commercial cash flow position for them. That's protected. However, the payment of the certified sum wouldn't preclude the tenant from later disputing liability for that payment. So this gave effect to the tenant's ability to have inspection rights and pursue arguable claims as to the service charge liability itself. Now, this would establish a pay now and argue later regime, which the court ultimately felt that this interpretation was consistent with the wording in the lease, and it enabled all the provisions of the lease to fit and work together, avoiding any unsurprising or surprising rather implications and uncommercial consequences that would result. So now just turning to our second case, in which the court considered the correct test to be applied as to whether a landlord had established sufficient intention to redevelop and satisfy the ground of opposition to a renewal tenancy under Section 31F of the Landlord and Tenant Act. This is something that will be important to landlords should they find themselves in a similar position wanting to redevelop. So again, there's a bit of background. The property was demised to the tenants, which they used as an American-style diner, pursuant to a lease which expired at the end of May 2018. Now, the tenant served a notice under Section 26 of the Act seeking the grant of a new lease, and the landlord served a counter notice relying on Section 31F, which provided that the landlord could oppose the tenant's application for a new tenancy. Now, in this case, the landlord asserted that it intended to redevelop the property, and it was going to do so for a multi-storey mixed-use development, and they had sought planning permission, which had been refused. So initially, the landlord was unsuccessful in its first instance before the county court and appealed to the High Court. And when the High Court looked at this, they clarified the test, the realistic prospect test, which the court would apply in the context when looking at the likelihood of funding and the intended redevelopment, in addition to their planning requirements. So if we start by having a look at the initial judgment, next slide, please. So the initial judgment found that although the landlord had the requisite subjective intention, it lacked the objective intention. So the judge concluded this looking at 2 points. The first being that there was a lack of any real prospect of the landlord obtaining planning consent. And secondly, that there was a lack of sufficient evidence for the landlord's ability to fund the development itself. Now, interestingly, between the draft judgment being circulated and the final judgment being handed down, the landlord's planning appeal actually succeeded. Nevertheless, the judge refused to reconsider his ruling as he found that the planning issue was not the only reason as to why the landlord had not established sufficient grounds under section 31F. And the landlord had failed to prove that it would be able to fund the development in a reasonable time after the end of the tenancy. Next slide, please. So the appeal, the landlord obviously sought permission to appeal on the grounds that, firstly, the judge's treatment and exclusion of late evidence on funding, which I'll go into detail in shortly, and secondly, that the judge's application of the legal test of intention in respect to the funding. So on the first ground of appeal, the court found that whilst there was some evidence of funding before the judge, bank statements that provided concrete evidence were not actually disclosed by the landlord until the start of its evidence at trial. And the landlord refused relief from sanctions in the first instance, and as such, the statements were not admitted. So the High Court found that the County Court judge was justified in not admitting this evidence due to the landlord's delay in disclosing the evidence. And additionally, the High Court could not criticise the County Court judge, given that it was effectively a classic judicial evaluative exercise, and there was no real prospect of them overturning the judge's decision on that point. They also clarified that the judge at first instance had not made any material error in failing to refer to evidence that supported the landlord's oral evidence in respect of other properties that the landlord actually owned for the purposes of funding. Now, whilst there was evidence of ownership of other property, no particular property had been identified in the witness statements as being available to fund the development, and accordingly, the High Court dismissed this point. Next slide, please. On the second ground of appeal, it was considered which is considered the legal test in respect of intention, and whether the judge at the first instance had set the threshold too high when considering the evidential burden in respect of the funding. The test is a realistic prospect test, and it's usually considered and applied to the likelihood of obtaining planning permission. So there has to be a real chance as opposed to a fanciful one. And the court agreed that the same test would apply again to the availability of finance. It was agreed in the appeal decision that the wording used by the judge in the first instance regarding funding referred to the landlord having to prove that it would be able to fund the development, which implied a higher threshold had actually been applied. However, when the High Court looked at the judgment as a whole, they took the view that the judge in the first instance had the right test in mind, and the appeal was therefore dismissed. So ultimately, I think this judgment illustrates the court's approach towards balancing the evidence in favour of and against whether there is actually a real possibility of a landlord both funding the development and being granted planning permission for any proposed development when applying in the context of renewal proceedings and using section 30F the Landlord and Tenant Act 1954. So I think now I will pass back to Vicky. I'm just conscious of time, who just wants to run through a data protection offering that we have.
Thanks, Mark. Yeah, so I mentioned earlier the importance of staff training if you want to implement appropriate organisational measures. We have some data protection e-learning. It's a sort of general module that will just test your staff's understanding. The benefit of it is, of course, that you can track and that people have actually completed it, which will be relevant if you have a data breach. If you would be interested in getting some more information about that, if you just click yes on the poll. If you're not interested, please do click no. And if you are interested, one of our team will be in touch to talk you through exactly what we offer and the costings, etc. And I think it's back to John to wrap up and answer questions.
It's actually back to me, Vicky. But
oh, sorry.
That's all right. I'm Steve Farragher. I'm a senior associate in the real estate team, and we've got about 5 minutes left. So we do have some questions. We just run through a few of these. Any we don't get to, we will we'll contact you directly and go through those afterwards. But first question I think is for you, Vicky. If you own an office building and the managing agent runs the premises for you and collects data for visitors, what obligations do you need to make sure the managing agent complies with?
That will depend, standard legal answer. It will depend upon the level of control that you exercise over the information that's being collected. So under GDPR, the data controller is the entity that's legally responsible for compliance, and you're the data controller if you control the means and purpose of processing. So if you decide what's collected, how it's stored, how it's used, if you're setting those boundaries, you are likely to be the data controller. The other entity is probably your data processor, so you should have a data processing agreement in place. There are mandatory clauses in Article 28 of the GDPR that you have to put into that agreement, plus anything else that you want to add around the edges. If, however, your managing agent is free to collect and use whatever they want, then you're not likely to be the data controller. And if you have no access to that information and you're not looking at it, then you may not have to implement any obligations. So it depends on the exact relationship between the two, what you're sharing, who's collecting on whose behalf, etc.
That's great, thank you very much. And we've got a question for Amory as well. If a tenant has served a break notice and then wants to stay in the property for a period after the break date for clearing dilapidations, etc., or because new premises aren't ready yet, and the landlord is in agreement with this, how would it be best to document that?
Thanks, Steve. So this can happen a lot because of, as you say, timings and not being quite ready to leave. The strict position is that if the tenant doesn't leave on the break date, then the current lease is continuing, which might be unsatisfactory for both parties. But on the flip side, it could be that a new periodic tenancy arises on that date. It can be a bit of a tricky situation. What you wouldn't want to do is any sort of interest inadvertently arising. And what's also relevant is whether the current lease is inside or outside the protection of the Landlord and Tenant Act 1954. So you wouldn't want to inadvertently give the tenant additional rights by letting them stay. I would say if it's literally a day or so before they need to vacate, you almost want them to physically vacate and then hand them back a set of keys to finish their work. So you're sort of saying your lease has ended, you've vacated, but you can go in and clear your final bits and pieces. If it's any longer than a day or so, then I think you want to document something new. So I would say it's safest to surrender the previous lease and grant them some sort of new short-term lease or perhaps a tenancy at will or a license, depending on what they need. But it's best to have something documented, because everyone might be in agreement on the break date, but all of a sudden the tenant has been in for an extra month or two, and the longer that informal type of arrangement goes on, there's room for arguments, or the tenant may say, well, actually, I've changed my mind, I want to stay, and you just don't want to get into a position where you've got a undocumented occupation. So I think the answer is, if it's more than a very, very short amount of time in which you could deal with a license or a permission, you should document any new period of occupation.
Thank you very much. Further questions just come in. This may not be a short answer, but can a landlord break be enforced in a lease which is not contracted out? I'm not sure if you want to just give some quick comments. We don't have much time left. But...
Okay, just very briefly. So if it's not contracted out, it's within the protection of the Landlord and Tenant Act. So a landlord can break the lease, but they will also need a ground under the 54 Act and be able to prove that at the same time. So essentially, they would be serving a break notice and a hostile Section 25 notice, or you can do it within one notice. So the break notice would only terminate the contractual term of the lease, but if the lease is within the Act, then the statutory tenancy continues unless a ground under the Act is proved. But it does happen. It's not redevelopment ground is a standard one where that might happen.
That's great. Thank you very much. I think that just leaves us now to say thanks very much to all the speakers, and quick date for everyone's diary. On the 29th of June, we have our London Commercial Property Drinks in the Gardens at our London office. So if you're signed up to the webinar, you'll be getting an invite shortly to that. It'd be great to see as many of you as possible. I think that's everything from us.